welcome back. It's time for this week's Capitol Report with Pat McGuigan of CapitolBeatOK.com. And Pat, I know that legal policy is one of your specialties. Let's talk about this case out of Tulsa and exactly what it means.
Well, the case out in Tulsa involved the Lindsay Nicole Henry Scholarship Program for Special Needs Children. And in essence, being a little provocative here, the case can be distilled down to: do parents of special needs children get to decide how the public resources to which their children are entitled to have access can be spent, or is that decision going to be made by public school administrators and things that they deem legitimate or sufficient or adequate? In this case, the judge, without comment, simply ruled to strike down the program and leave those kinds of decisions in the hands of the public school system. I think it's an unfortunate setback for a very interesting and modest kind of development of Oklahoma policy in terms of policy terms, but very significant to the 150 or so children that were accessing the program at this point.
So I know a lot of people felt like that was a controversial decision. What makes that so?
It's controversial because it comes down to, again, at the risk of distilling the issue, it comes down to that conflict between those values or visions of how money should be spent to help handicapped children. Going forward, I think you'll see, you might see a stay of the decision, but in any case, you'll see this pretty rapidly, most likely, go to the state Supreme Court. Then for that matter, you may eventually see it in the federal system because it contradicts rulings in Arizona and in Indiana. And in both of those cases, the judges recognized, I think correctly, that it puts at risk other uses of public resources in private settings: hospitals, foster care programs, pre-K programs, colleges and universities. So this isn't over, and the discussion and argument will go on.
And you were actually in the courtroom for a lot of this.
Yes, I was in the courtroom and watched the arguments. There was just me and one other reporter, and then advocates for the two sides. So it's not over. The battle will continue.
Okay, let's switch gears for a moment and turn to the nation's capital. This week, the U.S. Supreme Court hearing about the health care law. A lot of people have felt like that conservatives have made a lot of outlandish points regarding this law. What did you think about that after hearing some of what the justices had to say?
I'd be interested to hear what some of the tenured faculty at the University of Oklahoma School of Law would have to say after the very tough questioning of the Solicitor General of the United States by 4 of the justices, and then on the flip side, good, strong questioning as well from the more liberal justices of the position taken by a former solicitor, Mr. Clement, for the people arguing against the health care law. Now, in the end, again, just like I did a moment ago, at the risk of some distillation, this may come down to the battle for Anthony Kennedy's brain.
Okay.
And Kennedy has ruled 3 times on Commerce Clause cases, and in 2 of those he struck down the government's exercise of its commerce powers, which is the key issue here, as well as the taxation power. So can the federal government go this far in expanding its power through the individual mandate and its regulation of the insurance market and its use, at least indirectly, of the taxing power? The conservative argument, and argument for by some other analysts too, has been no, it can't. This is a bridge too far. The liberal argument has been this is just fine. So Kennedy, how will he turn? And then how will Chief Justice Roberts exercise his power? Because you always have to remember that either the chief, if he is in the majority, or the senior justice, if they are in the majority, decides who writes an opinion. So Roberts will be deciding who writes this. If he wants to uphold the law but have it narrow, he might give it to somebody like even Breyer. Or if it's a split decision, part to Breyer, part to Kennedy. On the other hand, if Chief Justice Roberts decides we're going to have to slap this down and make them start over, he may give it to Clarence Thomas, who didn't even ask a question, as he usually doesn't, but has a great mind in terms of federalism. So stay tuned.
Very quickly, your prediction.
I think that at least parts of the law will be struck down. The problem for the supporters of the law is that the president and his allies deliberately abandoned severability, which means you can excise a part of the law. However, the Supreme Court has the power to overcome that.
All right, thank you, Pat. And for more on these and other topics, just go to CapitolBeatOK.com. For Pat McGuigan, I'm Kirsten McIntyre. Have a great Saturday, everyone.